Good morning and welcome to today's Estate and Trust Administration webinar presented by Elville and Associates President and Managing Principal, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. How this will work today, you are on mute. However, when you have questions, please note them in the questions panel in the right-hand portion of your screen, and we'll take time to address those throughout. You received the presentation this morning from me by email ahead of time for your convenience to take notes on it if you wish. For CFPs and CPAs on today's webinar, you may receive 2 continuing education hours for attending. And per attendance records requirements, please email me your board ID, and for CFPs as well, the last 4 digits of your social security number as soon as possible so I can submit my record reporting requirements to get your CE approved as soon as possible. Everyone also will receive a post-webinar feedback email right after the presentation. And we do ask that you please just take a couple minutes to fill out this simple survey to offer us some valuable feedback about the presentation. It's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have. And we'll also have some other options to get in touch with us to offer a consultation with Steve as well afterwards. So very briefly, an overview about our firm if you're not familiar with us. We were founded in 2010 in Columbia by President and Managing Principal Stephen Elville. We have a number of different practice areas and services here at the firm, and they include estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and business succession planning, guardianship and litigation, as well as tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and our mission, as it has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We offer a lot of education and focus on that here at our firm, and we do that through our planning processes with our clients. We offer well over 100 educational workshops and webinars in the communities we serve each year, and also by way of our accredited client care program. And 5 years ago, our team went up to Boston, Massachusetts at the Client Care Academy in Boston and got accredited through the Client Care Academy, and we're the only firm in Maryland to have that accreditation. So it's a very robust program, lots of different benefits, and many of our clients take advantage of that program. We also focus on the ideals of client education, collaboration, and compassion every day with every client, every time. So you should expect nothing less from us anytime that you work with us here at Elville and Associates. So a little bit about Steve, our presenter today. Very privileged to have Steve with us as our presenter. His work as an attorney for the past 20 years has been centered in elder law, estate planning, and special needs planning, with an emphasis in the areas of tax planning and asset protection. A member of many membership organizations. He flies, when able, all around the country to a number of different symposiums and conferences to be on the leading edge of the latest information to serve our clients. A member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, National Network of Estate Planning Attorneys, always working to bring peace of mind to clients, creating solutions to their needs through counseling, client education, and the use of the most leading edge legal technical knowledge. Last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association, each year presenting at about 75 different webinars and workshops around the area, and again, a very seasoned speaker. Last year named to the Maryland Super Lawyers list for a 5th time. Also had a feature story written about him in the National Super Lawyers magazine about our charity that we're very proud of here at the firm, the Elville Center for the Creative Arts. So that's something that we're very proud of here, Steve being very philanthropic in nature. And if you're interested in learning more about our charity, please contact me, Jeff Stauffer, the Executive Director of the charity, and I'll be happy to share more about that with you. So we're going to start off today with a brief poll to understand your background in estate and trust administration and I'm going to launch that poll in just a moment. So you should see it pop up on your screen, and then we'll go ahead and get started. So the question is, what has your experience been with estate and trust administration to date? And we're going to launch that poll. So the response options are, I'll put my glasses on to read them, is I have been the executor of an estate in the past on my own. As an executor, I sought professional guidance throughout. I may be asked to be an executor of an estate in the future. I want to keep my planning in order to keep costs down. Or lastly, I'm an advisor here to learn more to better serve my clients. So you just take a few seconds to offer the best response that applies to you. We'd appreciate it. And responses are coming in. We'll take just a few more seconds. Looks like we have a varied group here today. Okay, and they've slowed down. So looks like 14% say they've been the executor of an estate in the past on their own. 10% say, as an executor, I sought professional guidance throughout. 28% say, I may be asked to be an executor of an estate in the future. 24% say, I want to keep my planning in order to keep costs down. And 23% lastly say, I'm an advisor here to learn to better serve my clients. So Steve, you have a varied group here to learn and be educated today. So we appreciate you being here. I'm going to close that poll out, and I'm going to go ahead and switch the controls over to your hands. You should see that pop up, Steve.
All right, I am, Jeff, taking control of the screen there, so to speak.
Very good. See it?
Very good. And I'm just going to see if I can move the screen forward, Jeff. Let's see. Yes, I can. So thank you, Jeff, and I'll take over from here. Good morning, everyone. And thank you for attending today's webinar. And I'm looking outside my window here, and it's sunny, and it's October, and the leaves are starting to turn, and it's beautiful. So we appreciate you spending time on a very valuable Friday morning for you to learn more about estate and trust administration. We love to educate, and it's my privilege to take you through about an hour to an hour and a half discussion this morning about the trust and estate administration process. And I want to thank Jeff for being our moderator. I always like to have an attempt at humor, so I'll say that Jeff told me that he was mentored by Chris Wallace and Larry King, but I don't know whether I believe that or not. So, but he is a wonderful moderator in and of his own right. And Jeff is going to be taking your questions throughout, and he's very good at that. And we will stop occasionally in the presentation. But again, I thank you for attending, and I hope everyone finds themselves this morning well and healthy amidst this continuing national and world dilemma and all the news we got this morning. So a lot going on, but on this beautiful day, we'll go ahead and just get started. So as the survey indicated, many of you are attending for different reasons. And we have members of the general public, I'm sure, on this call. We have past clients or current clients of Elville and Associates, or maybe of other law firms or CPAs and financial advisors. We have people on this call who may have recently lost a loved one, and we send our condolences out if you find yourself in that situation and now you have to administer an estate. So we're aware and cognizant of that. But our goal here today is to educate, number one, and to make the process of administration more smooth, to help you along those lines, and really also to give you a path forward. So one of the things that I learned a long time ago as a lawyer was that, you know, it's one thing to give clients advice and or the general public advice, I should say, And it's another thing to make sure that people understand that there are solutions, there are paths forward. So we want to do all that today. We want to educate you, but we also want to give you a path forward so that you know there are resources. And one thing that's kind of funny or maybe counterintuitive about administration, trust administration or estate administration, it actually can be challenging and enjoyable despite the loss of someone that caused the administration. It actually can be a process that can be smooth, it can be orchestrated. But of course, there are problems and there are pitfalls. So we're going to talk about a whole plethora of information today that hopefully you'll walk away from today with something that you can use and something that you can use as a resource. Now, I want to show you that we do have a couple of exhibits, and I'm going to hold this up. These are critical date checklists. We're going to be talking today about a lot of things related to process and how process is king, and process is going to make our lives a lot easier in estate and trust administration, as process does in many aspects of life. So with that in mind, we're going to move forward, and I'm going to now advance the slides. So as a brief overview of today's presentation, we're going to be talking about unraveling the mystery of what happens at death. Even though today we're going to be talking about a lot of common sense things and things that you could, if you studied, unravel on your own, this issue of estate administration is one of the most confusing things. It's one of the biggest things, especially in trust administration. If I had to take a survey of the pertinent questions clients have asked over the years, one of the number one questions that is asked is, what happens to my trust on the death of a loved one or on my death? So this is one of the biggest mysteries, and we're going to get rid of that confusion today and cut through the mystery. So we want to minimize confusion and provide maximum support to family members, or if you're an advisor or another attorney on this call, to clients at a time of crisis. We're going to look at the legal step-by-step process, and we're going to talk about the practical steps. We're going to examine significant and problematic legal and tax issues that advisors and clients and the public should be aware of. And we're going to talk about how advisors, and I'm using that term very broadly, CPAs, trustees, financial advisors, personal representatives, and attorneys can all work together. So we're going to be talking about all of those things. Now, with all of those things said, there's another bullet point that I probably should include, and I would write this down if I were you. One of the reasons that you would want to know about these issues, if you were a fiduciary, if you were a personal representative / executor of an estate, Maryland calls that the personal representative, or if you were the trustee of a trust, what would you be concerned about? You would typically be concerned about, how do I uphold or carry out my fiduciary duty? So one of the bullet points here really should be to show you how to fulfill your fiduciary duty. And why is that a big issue? Well, as you may already know, if you're serving as a fiduciary, this is a very big deal. You are now in a position of fiduciary duty, fiduciary responsibility. You have to be accountable. You have to account for all aspects of the estate or trust. And if you don't, one of the things that most people don't think about is, well, I've breached my fiduciary duty, and now what could happen? I could be removed as a personal representative. I could be reprimanded. I could have someone drag me into court or into the orphans court. I could be sued. So these are the kinds of things that we want to educate about to avoid, especially not only the legal liability and the financial liability, but also the emotional and personal responsibility. Can you imagine the emotional turmoil in a family, or the pain involved to you personally, if you were removed as a fiduciary because of a lack of fulfilling your fiduciary responsibility? So we want to talk about all of those things, not just these bullet points in general. All right, so as I just mentioned, this is one of our clients, and I would venture to say broadly, most clients' greatest concerns. What happens after the death of a loved one? And the process, as we're going to see in these checklists that I've handed out, the process is similar. And that may be surprising for you, but it's a similar process for wills, meaning the probate process, versus trust administration, which is non-probate. It's a similar but different process. And there's a transitionary period. So some people, let's just talk about this. Some people say, well, if I have a revocable living trust, what happens on the death of a spouse, or what happens on my death if I am the last person to survive, or if I'm not married? Well, what happens is there is a living trust in that example. It was a living trust during your lifetime. It was identified by your Social Security number. And for purposes of taxation, this was no different to Uncle Sam than yourself, whether there was a trust or just yourself, if that makes any sense. But now at death, there is a transitionary period. That trust has to be administered. So there is a date of death, and there's a date of death value of all the assets. And now the fiduciary, the successor trustee, has to administer that trust estate, and I'll call that the transitionary period. There's a transition between the time of death, where all the assets are valued and all the expenses are accounted for, and then finally there is a distribution. And when you think about it, it's very similar to a probate estate. Someone passes away, the assets have to be valued, and there's a date of death value. Then there's a probate process, an administrative process, and then at the end of that process, the assets are distributed according to the terms and provisions of a will, or in probate, if there is no will, according to the laws of intestacy. Now, before I go any further, as we get into the presentation, many people who have attended this workshop in the past have asked me, Steve, these examples you're going to give in a few moments, they're great examples, but please focus more on the mechanics. So that's what we're going to do as we go through the next several slides and we get to the examples. I'm not going to spend as much time as I usually do on the examples. By popular demand, I'm going to go more into detail on the mechanics of the process, and hopefully that will satisfy a lot of folks who are looking for that information. But as we continue to unravel the mystery of what happens on the death of a loved one, we ask these questions. Who will be there for the surviving spouse? Or if there is no surviving spouse, who will be there for the children? What do I do if I'm a fiduciary? What do they do? What is this process, and how do we start this process going forward? And the question is, should I be driven by a process? And the answer is yes. You're going to hear me say that redundantly throughout this presentation. We don't want to be driven by circumstances. Now, many times, to avoid being driven by circumstances, there's nothing that you as a fiduciary could have done if the person who died, the decedent, did not have their planning process already organized, their assets organized. If they leave chaos for you, there's not a whole lot you can do, but you can be driven, even though there is initial chaos, you can be driven by an internal process. And of course, we want to prepare through planning, education, and organization. And that's what I was just alluding to during our own lifetimes, to make sure that we're making things as easy as possible, whether we have a will or a trust for our fiduciary. Now, I'm going to give you these case examples that I just mentioned. My attempt here is to give you a broad overview of just or a flavor of the types of situations that you may encounter or that you may be currently dealing with if you're a fiduciary. And I tried to lay these out as a plan-specific structure. And this is a situation where someone has passed away and it's pretty clear what has to happen. The plan was clear, the structure is clear, the process is clear. And then an asset-specific example where there's many retirement type assets or non-probate assets that are strategically designed to flow in different ways. So I'll attempt to give you an example there. And then what I would call a needs-specific situation where there's a survivor, and this is a married situation. So for those of you who are dealing with single decedents or you're not married, you'll have to just bear with me on this particular set of examples because we are showing what happens between spouses and the difference in the situation. There was a certain situation on the death of one spouse, and now there's a different one. The situation has changed. Or what I will call a very fact-specific driven situation. There was no plan, there was a little bit of chaos, there was a poor plan, and the fiduciary has to make some kind of judgment call. And so everything in estate administration or trust administration is not always exactly clear, just like situations in elder law or situations in life in general. There are no hard and fast rules sometimes. So let's look at this first hypothetical fact pattern. And here we're talking about, if I'll just go backwards for just a second, this is our plan-specific situation where there is a clear plan. So in my example here, a single person, not married, Felix has never married, but he has a child. He's an unmarried person with a child. And he passed away at age 77. He had a residence, like many people. He had cash. He had checking, savings, CDs, all equaling about $200,000. He had IRAs. He had an IRA or one or more IRAs totaling $400,000. And look at this. He was a big believer in U.S. savings bonds. So he purchased savings bonds. And as a matter of fact, I'll just throw this in that at Felix's death, he had a bunch of paper savings bonds in his safe deposit box. He made no lifetime gifts. And remember, at the time of Felix's death, which I will hypothetically illustrate that happened in 2020, at the time of his death, the exemption amounts for gift tax and estate tax is $11.58 million per person, and it's $5 million for Maryland, but he had never made any gifts and he had no creditors. He had Social Security income, and he did have an estate plan. He had a will and he left everything to his son outright. So just covering this real quickly so we can focus on the more of the mechanics later on. We know that by its very nature, Felix's estate is going to go through probate because he had a will. There's no indication that the house is owned in any other fashion except in Felix's own name. His cash is going to go through probate because there's no indication it was joint with Charles. There's no indication that it was payable on death to anyone. So that's going to be an asset that's in his probate estate. His IRA, I think we're going to assume that it was beneficiary designated. So let's pretend it was beneficiary designated to Charles. And now Charles cannot just demand his $400,000. What does he have to do? He has to claim that $400,000 IRA. And your responsibility, if you were the fiduciary here, is to make sure that Charles can make that claim. And so he makes that death claim and he sets up what? He sets up an inherited IRA. And we know Charles will have that IRA and he can choose to do whatever he wants to with it after his death. Now, what do we know about this inherited IRA that Charles is just now getting? We know that because Felix died in 2020, that Charles, as a healthy person, there's no indication here that he is disabled or that he is exempt from the new rules under the Secure Act. So we know that Charles will only be able to take this inherited IRA for how long? 10 years, and then he will have to pay all tax on that IRA if he has not taken all the money out after the end of 10 years. Savings bonds. So now what do we do as a fiduciary? Well, we know that if those savings bonds were in Felix's own name, we know that those are going to go through probate. But savings bonds are what? Income in respect to a decedent, IRD. They are very similar to IRAs in that a traditional IRA like this one, there's no indication it's a Roth IRA. There's going to be income tax due when Charles takes that money out of the IRA, out of the inherited IRA. Savings bonds are the same way. The tax would have to be paid when those are cashed out now after the death of Felix. And we know that there could be sizable income tax here. So you as a fiduciary, along with your attorney or CPA, and particularly possibly a CPA, would crunch the income tax numbers here and decide, is it best for Felix's last income tax return to have all this income on it, or Felix's probate estate to pay some of this tax, or the beneficiary to pay the tax, or all three? So that's a calculation that would be done. So all in all, the personal representative of this estate now has to open an estate, value all the assets as of the date of death, and start the estate administration process, which in Maryland routinely takes about 9 months. We're going to talk about that a little bit more, but it's not always 9 months, but that is a good rule of thumb. The first account is due in about 9 months. Now let's look at a second fact pattern. Now this is a married person, and I hope you're following me because I'm moving rather quickly here. Jack, who is 69, was married to Janet, and they have 3 children. And in my example here, Jack has passed away. He is the first person to die in this couple's estate. Now let's jump right down to the bottom here. We have a revocable trust. Now this could be 2 separate revocable trusts, one for Jack, one for Janet, or it could be a joint family trust. So we don't know that information here, but let's just, for purposes of this illustration, it doesn't really matter whether it was joint or not. The disposition to the surviving spouse is very simple. We see here that Janet is going to receive the assets from Jack outright from the trust. Very straightforward. And you'll see here with disclaimer. So she has the right to make a tax election after she receives everything outright. And basically for federal estate tax purposes, she has 9 months to decide whether she wants to disclaim any of those assets. Now, looking at this and eyeballing these numbers, it looks like Jack and Janet are well under 11.58 million. So when Jack died, he had an 11.58 million exemption. So Janet will probably not need to use this disclaimer, but it's there as a backup. Now let's look at the assets. So we have a residence, we have checking and savings of 140,000. Jack had a significant 401k and IRA. Janet has less money in this example. They have a joint brokerage account of 600,000. Life insurance, so they have some fairly significant life insurance for people of their age group. And look at this, they have a residence still over there in Delaware. They enjoyed the Delaware shore, and now they have a second home. There's no indication that this is a rental. And they've never made any lifetime gifts to children or anyone else, and they have no creditors. And Jack's income was modest. He had a Social Security income of $2,000 at the time of his death. So what do we know here? Well, this is going to be a rather simplified version of administration because we have a spousal situation and Jack died first. So basically the transitionary process, remember we mentioned that? The transitionary process is really just to administer Jack's trust or his portion of the joint trust, which in our example will be an imaginary 50%. Jack owned 50% in this joint trust, or he had a separate trust of his own, and now everything goes to Janet. So the residence will pass to Janet because in our example, Jack would have owned 1/2 of this residence in his revocable trust. So that's going to pass to Janet outright, and she's basically going to retitle that in her trust. She will move on with her life and she will have a revocable trust. Same thing with the cash, same exact thing. It's going to be transitioned over to her if for whatever portion of the cash she does not already own. The IRA, Janet is going to make a death claim, and the 401k, she's going to make a death claim. Does the Secure Act apply to Janet in this example? And the answer is no, because she's a spouse, she's exempt from the Secure Act, and we know the distribution to her is outright. So Jack is just left everything outright to her, including the 401k and IRA. She will 9 times out of 10 take a rollover IRA and not an inherited IRA. So you fiduciaries out there, or to-be fiduciaries, remember that a surviving spouse can take an inherited IRA or a rollover IRA. And most of the time, it's going to be just taking that new IRA, the rollover, to their own name. The joint brokerage account. So this is going to be the same exact thing. Jack owned half in his revocable trust. He's now passing that half along to Janet with no strings attached, no marital trust, no marital protection. Janet now has this outright, and she can do whatever she wants to with it. Of course, she's going to leave it to the kids. Life insurance. Jack's life insurance paid directly to Janet if he left her as a beneficiary, or he might have done what we do many times. We take Jack's revocable trust, we treat it as a funnel, and his life insurance would go directly into that funnel to funnel down to Janet. So it doesn't really matter, but one way or the other, that $265,000 got to Janet. The Delaware residence was also owned 50-50 in this example in each trust. Jack's portion now comes over to Janet's, and her trust will now own the Delaware residence. So this is a pretty straightforward situation. What are we concerned about here? Well, with all of the political goings on and all the upheaval in our country right now, we know that Janet would probably be the surviving trustee here as the surviving spouse, and she simply would enter into a process of retitling assets. And what would she do? She would file final tax return. She would close out Jack's trust, and she would do something very important, in my opinion, or she would at least get some advice on this. She would choose the portability election after Jack's death to lock in those exemption amounts, because remember, a lot of people are concerned right now that those exemption amounts might go away very quickly after the next election, depending on who wins. So we probably would be cautious and make the portability election, which means that Janet can use the exemption amounts that Jack had at the time of his death. She can port those to herself, and she has to make that election on Form 706, and she would check the box. It's a little bit expensive to do that, but in my opinion, that would be the thing to do here, to file the Form 706 to make the portability election for both federal and then, of course, on the Maryland MET1 to choose portability all around, so that she does not lose the exemption amounts if the exemption amounts are somehow lowered in the future. Now, keeping true to my promise that we're going to look at the mechanics more specifically today, I'll move on. Now, here is the surviving spouse death example. Still a person who was married, Janet. She survived Jack, as you know, and she survived for 20 more years. So this is a great example. By the way, in the last example, the children were all healthy. There was no indication that there was any problem. But now we see 20 years later at Janet's death, one of the children, heaven forbid, has been injured. They've probably been injured in a car accident, or there was some kind of a self-induced accident of some kind, and there's a traumatic brain injury in my example here, which is purely hypothetical. So now we see that Janet, at the time, 20 years later, many things have changed. She is now living in a continuing care retirement community. She sold the house that she was living in, and it looks like here she sold the Delaware house. And now she was actually owning a residence in Florida at this time. So the CCRC could be in Florida, and it looks like at some point in that 20 years, she kind of relocated down to Florida and owns that at her death. So if we're lucky, and hopefully she did all of her proper funding and alignment, her $350,000 deposit at this continuing care community, depending on the contract, that $350,000 will be funneling back to her trust and hopefully being redistributed to the children, depending on the contract. It may or may not be coming back. And look, we still have plenty of cash. So that was in her trust. So there's no probate there, no probate on the CCRC deposit. Look at the IRAs. The IRAs have grown now. She has 1.2 million 20 years later. That is going to be beneficiary designated to the children, because we look down at the bottom of this illustration and we see that Janet still has her revocable living trust. She had her trust and just continued on throughout her life. And you see here that it was very simple, just like Jack left everything to her very simply. She's leaving everything to the children very simply, but with one twist. She's leaving it equally, but in further trust. So Janet decided in hindsight, as she continued to review her planning over the years, that she wanted to give her children protection, protection against something, bad marriages or divorce creditors or bankruptcy creditors or those kinds of bad things. And she decided to leave the assets in trust. So all of these assets, including the brokerage account, which is now up to 1.3 million, she has some life insurance of her own and the Florida residence. All of these things now, because Janet handled things properly, all of these things are either in her trust or properly designated to her trust. Let's talk about that. The life insurance probably was beneficiary designated to the trust itself and flowed through the trust. The IRAs, why is this a big deal? Those should have been beneficiary designated to the trusts for the children, because one of the things we know is that the Supreme Court ruled many years ago that inherited IRAs, this exact example where IRAs are flowing to children, those children have no protection from creditors in the inherited IRA. So Janet here funneled those IRAs into the further trusts for the children. But there's one problem. We see that one of the children has an injury. So now what do we have? We have a double trouble kind of situation. What we want to do is make sure that if this trust did not provide for a way for this person to be protected because they now have special needs from the traumatic brain injury, we know that this trust is probably for their general needs. Here's an injured person. They could need brain injury therapy that costs anywhere from $20,000 to $40,000 a month, not a year, a month. And they could need tremendous care for the catastrophic injury. And now we know that all of this money, including the IRA money, is coming to that person to be in their trust. The problem here is that that trust is for their general needs. And even though it's a healthy amount of money they're going to be receiving, the money will not last very long to take care of this person. So hopefully the trust itself provided for an alternative way for monies to be put into a special needs trust for the injured person. And decanting might be needed. And decanting, if you've never heard of this, is something that is in several states. Maryland does not have decanting, but for example, Delaware and Virginia do, and Nevada and South Dakota and Alaska and several other states. This is a way to change this situation. So you as a fiduciary might say, well, listen, I want to do the highest and best thing for this injured child. So I'm going to start a process of decanting. I'm not going to distribute all this money into a general trust for this child where they won't have any money 3 years from now because of their injuries. I'm going to decant that trust or change it to a special needs trust through the decanting techniques that hopefully could be used in that circumstance. So here we're getting at not only several examples of what to do in the administration of this trust, but we're talking about how to do it at a very high level where you're taking all the facts and circumstances into consideration. All right, here's our fourth and final fact pattern before we get into mechanics. And here we see a person who is really married, but he's separated. And he, at the time of his death, he had 2 children. And his spouse, and they've been separated, but they've never divorced, actually lives in a very unique community in another state. And one of the children in this example is in bankruptcy. So that's not a good situation for the surviving children or one of the children to be in. Now look at the bottom of this slide and please note that here this gentleman, Ricardo, had no estate plan. So he does not have a will, he does not have a trust, but he has some cash in checking and savings. He has an inherited IRA of his own. He actually could leave this by beneficiary designation, and hopefully he did. Hopefully he left all that money by redesignating beneficiaries after he received it. If he did not redesignate beneficiaries, then that inherited IRA would likely go through probate. So the checking and savings will go through probate because it has no payable on death beneficiary, no joint owner. The automobile will go through probate. The life insurance, see, no beneficiary, so now that's going to go through probate. The savings bonds were in his sole name. We know that will go through probate. And here we see that, well, at one time in his life, Ricardo had a lot of money and he gifted away $500,000 in lifetime gifts. So he used some of his exemption amount. He actually used some of his 11.58 million of gift tax exemption. So the bottom line here is that we have a federal pension that's coming to an end, but we have a lot of probate assets because not only did he not use a trust, but he didn't have a will either. So how do these assets flow? Well, let's just assume the IRA had no beneficiary. Let's assume the life insurance had no beneficiary and the savings bonds are in his sole name. We know, according to the laws of intestacy, that this is going to flow down approximately 1/2 to his surviving spouse. And he may not have wanted that because she's chosen a different lifestyle. It's unknown why they never divorced. But it's going to flow down partially to her, depending on the state law at that time. And his children are only going to get about 1/2. And lastly, on this example, we've got one of the children in bankruptcy, not a good thing. So here, there's no protection for that child. There's no document providing that that child is going to be able to have a trust that shields their assets from bankruptcy. So unfortunately, the personal representative or executor here is going to be forced eventually to distribute assets to the children, one of whom is in bankruptcy, and who knows if that money will be lost in bankruptcy. So that would be sad. Also, Maria, who lives in this other state, she is entitled to receive everything outright, regardless of what Ricardo really wanted, because he did not wrap up his affair. So this is the fact-specific example where we have a little bit of chaos, but we still want to be driven by a process. So Jeff, I'm going to stop there after a big foray there of examples and see if there are any questions.
Thanks, Steve. Do have a question or two here. The first one is there insurance one should get if they are trustee or personal representative? Should one get insurance even if the document appointing the person waives the requirement of a bond?
That is a great example, and occasionally, thank you for that question, occasionally we do get that question, and the answer is, well, there are provisions in many trusts that do exactly what you just said. They waive the requirement of bond, and some documents go as far as to exonerate the trustee as long as they act as a prudent person would. Now, with that said, if you have the ability to obtain this kind of insurance, the answer would be yes. If you're concerned about it, you must have a reason for being concerned about it, and you recognize that you are in a position of responsibility and liability. And one of the things you could do, of course, is be represented by an attorney who is really charged with protecting you and making sure that you have not exposed yourself to liability. But if you want to go one step further, and if you find this type of insurance, which it does exist, if you find it's available and you would like to purchase it, the answer is yes. It cannot hurt, especially if you are concerned about it. Most people do not do that. They do not have this kind of trustee or fiduciary insurance if they are a non-professional, if they're a layman, but the answer would be certainly yes if it's a concern.
Thank you. Another one, I'm going to read it slowly because it's a little bit long, but it is important. So I have two questions. I expect to be co-executor of my mother's estate with my sister. About 10 years ago, my father passed away. Together, they had a trust. However, I do not think that my mother has updated the trust to reflect the fact that she is now single. How important is that? What should I encourage her to do? 2, my mother also has not filed or paid state or federal taxes for several years. What will happen upon her death? Thank you.
Great question. And I thank you for these questions and the former one, because it does add flavor and helps us tremendously in our presentation. So I would first of all say that every situation is fact specific. So I'd have to see the trust to really understand what it says. But my assumption, and of course this cannot be taken as legal advice, but my assumption is this was a joint family trust of some kind. We would call that a joint family revocable trust. And if it hasn't been updated over time, it probably provides for everything to go to the survivor, your mother, and then everything to go to children or other beneficiaries. And as long as she still agrees that that disposition, that structure of disposition is what she wants, my guess, not having looked at the document, is that you would not need to do any updating. On the other hand, if it's been 10 years since your father's passing, then your mother would typically want to update her documents just to make sure that she has all the new contemporary provisions. She's up to date with Maryland law and making things as easy as possible for you at her passing. And that would just be a general recommendation, because normally on the death of a spouse like your father 10 years ago, your mother would have typically updated her documents and made sure everything was kind of, we've got all of our ducks in a row, so to speak, going forward. So at her age, I'm assuming she's not a youngster, I would say she should be updating every 2 years. Now, your second aspect of your question is the tax situation. So tax returns have not been filed, and where that occurs, you or your siblings or whoever will be the fiduciary at your mother's death will have a responsibility, depending on the circumstances, to make sure that tax returns are filed. And this is fact specific as well as to whether or not you have an obligation to make sure that all tax returns are filed. But generally speaking, if the decedent, someone like your mother who passes away, has not filed his or her income tax, then the fiduciary is responsible for making sure that all taxes are paid as part of the IRS being a super creditor to the estate. And then the responsibility in many circumstances would flow to you if you did not fulfill that obligation.
Okay, Steve, thank you. I think that is all for now.
All right, well, thank you for that. I'm checking in on our time here, and it looks like, Jeff, we've been going for how long? About 45 minutes. So I'll just keep moving.
Yep, sounds good.
All right, so we're going to get into the mechanics now. And some of this is personal and common sense, and some of it is technical. So a good fiduciary, in my opinion, has a good combination of both of these things. So we want to have empathy for the client or the fiduciary situation. And if you're a fiduciary, you want to have empathy for the survivors and those folks who have lost a loved one. That's key, actually, to be a good fiduciary. What kind of family support does this person need? If you're a professional, the whole firm, your whole practice should be involved in this kind of support. We want to be creative, whether you're a professional or a lay person, and be informed about resources, because what do people need at a time of crisis? They need resources. And you want to be that person who can find resources or provide those resources. And you want the ability to refer to and act as a counselor. You want to coordinate. One of the things that we see in administration is that even though it's a very high and best practice for there to be an advisory team, for example, it's sometimes unclear who is going to coordinate that advisory team in the best interest of the fiduciary and the family. So we want to assure the client or the fiduciary or the person who has suffered a loss that they should take care of themselves first and that there's no hurry most of the time. Now, we are getting lots and lots of calls from clients that are very nervous. As you can imagine, many of you are nervous about the political situation, the health situation, the national and world situation, and the tax situation. So sometimes we do want to hurry, but in most cases, we want the survivor or the fiduciary to be calm, measured, subject to a process. We want to assure them that all advisors will be working together and that we will work hard on that to make sure that everyone is notified and coordinated. Much of this, as you can imagine, should take place before someone dies. We want to assure people that everything is in order, assure people in crisis, or the fiduciary wants to ensure that everything is in order as soon as possible and that funds are available. This is a part of the fiduciary responsibility, but also part of the planning that should have taken place before someone's death. We want to assist with final arrangements, and this may seem like a very simple thing, but funeral homes and cremation services and so forth, they need to be paid. And we want to make sure this is smooth, and we want to make sure they are assured that they will be paid. And believe it or not, many times they don't get paid, which is why the Register of Wills is so focused on who is paying the final expenses and making sure that happens. And if someone fronts the money for final expenses, that they get paid as a first priority. And we want to assist with family-related issues. Many people have issues that happen at a time of death where there are family members in crisis, family members that are not getting along, family members that have health needs that have to have continuity, and of course, simple things like attending funerals and memorial services or sending sympathy bouquets, making sure we are sensitive and technical at the same time. So what is the legal step-by-step process? So let's talk about this. So probate versus non-probate. Now, probate, remember, is the process of proving a will to be valid. It's the process in Maryland, for example, that is a bit onerous. There are efforts underway to make it less so, but for example, I understand that Virginia is much less onerous in its probate process than Maryland. But we want to understand that probate is where there's a will and there are probate assets, assets that have no joint owner, assets that are not beneficiary designated. Those are probate assets, assets in someone's sole name with no beneficiary, no joint owner, versus non-probate assets. Back to probate assets for just a second, covering once again, there is a process of probate if there is a will and we have probate assets versus no will, but we still have probate assets, just like the Ricardo situation. Non-probate. Non-probate can be transfers on death, TOD, POD, payable on death, beneficiary designations, revocable living trusts that are completely funded with assets. In the examples I gave, no probate. Those are various examples of non-probate. These processes are similar, but have some differences. And as I mentioned, we want to use these critical date checklists or others that you will get from your advisors or from the internet and so forth. And organization is the key. The people that I've seen that are most successful in administration are very organized, very methodical, and I always use this silly analogy. They're almost like conductors of an orchestra that have everything in front of them and they are just conducting the process because they're so organized, they are out in front of the issues. That's not always possible, but that's the goal. So as we look at our checklists and as we look at these slides just for your convenience, we want to always know what is the date of death, value, and get the death certificate issued. So this can be a problem. We've had some very wonderful fiduciaries who have been very proactive in the COVID-19 period, and where death certificates were slow in coming, they were very proactive and got those death certificates issued. in a letter of administration in a probate estate is going to be issued. So the first thing you're going to do is you're going to open a probate estate, and you're going to have a tax ID number, and you are going to open up an estate checking account. So we have the date of death, we have the death certificate. That leads us to a petition for probate, where we are issued letters of administration. And now we've got some timelines that start, and they start from the date of death. And we know that 3 months in Maryland, 3 months into a probate estate, we have an inventory that is due. So when we opened that estate, the registers of wills say, you don't really have to tell us how much everything is worth in a regular estate. So in a small estate, we do have to tell the register of wills. A small estate, let's say, is $50,000 or less. The register of wills is going to require that we prove how much was at the date of death. And now, if we are over 50,000 or 100,000, depending on the spousal situation, and if we have a regular estate or a large estate, now we have 3 months to tell the register of wills exactly how much the assets are worth. So this is where, in that 3 months, we get date of death values from the brokers. We get an appraisal of the real estate, and we are valuing the property, and that's what we're doing in 3 months. The information report in a probate estate is really asking 4 major questions, because the register of wills collects inheritance tax. Maryland is one of the only states in the country with an estate tax and an inheritance tax. So the Maryland inheritance tax is roughly 10%. It's been eliminated for most beneficiaries that are lineal descendants, but for non-lineal people, for example, nieces and nephews or friends or people that are remote like that, they are going to be subject to inheritance tax. Well, the way the Register of Wills finds this out in a probate estate is they ask the personal representative to complete this information report. And many times there's nothing to report, because no assets are going to a person subject to inheritance tax. But many times there are assets, let's say $10,000 going to a niece. Well, that niece is going to be subject to 10% inheritance tax. So these are the kinds of questions that are determined in the information report. There is a valuation date that can be alternate from the date of death. We call that the alternate valuation date in some instances that would be used. Claims against the estate. So we know that a probate estate is subject to the claims of creditors, as is a revocable trust administration estate. So we know that the date of death starts the 6 months. So it is not from the 6 months from the time of opening the estate. It is 6 months from the date of death. Now, the spousal election is subject to a timeline, and you need to be aware that as of October, and we are in October now, there is a new augmented estate. This is something that is beyond the scope of our discussion today, but this is a new law called the New Spousal Elective Share Law. So the surviving spouse is entitled to at least 1/3, and I won't have time or the ability to explain this today, but you as the fiduciary, as the personal representative, will be subject to the rules and regulations of this new law, which is quite complex compared to the old law, but it protects surviving spouses, where the surviving spouse must at least get 1/3. So this is something that the registers of wills across Maryland will be calculating to make sure that the surviving spouse is protected and is not completely disinherited. Disclaimers. We mentioned the fact that in our example, the first spouse to die in that married couple's estate, he had left everything to his surviving spouse. She had 9 months to make a tax election. 9 months. Now, she probably wouldn't make this disclaimer tax election because she has the blanket portability amounts that are huge right now, subject to whatever is going to happen in the future. But the disclaimer for federal tax purposes is due in 9 months. If the disclaimer is not made for federal tax purposes, the 9 months is not a limitation. And federal and state estate tax returns are due, I should say, in 9 months. The portability election is due in 24 months. So there are various timelines, and that's why I want you to refer to these checklists. And you can see we're giving you a very broad overview today. I know this is a lot of information. So as we continue, we see that there are various timelines. The Q-tip election, this is a marital trust election. Now you'll notice in the Janet example, when her husband died, he left everything outright to her. But if I were to go back to that example, which I'm going to go back to very quickly here, we see, if you look at the bottom of this slide, there's another example here called the formula clause. So if you are using a pen or pencil here, I would also write another category here that says straight marital trust. Straight marital trust. So here in this example, everything went outright to Janet. So there's no need to make the Q-tip election for purposes of establishing a marital trust. But if Jack had left a formula clause, and we don't have time to explain that too much today, but a formula clause is what many times you will see in older documents or even in newer documents where the trust has a formula or the will has a formula that creates a marital trust or what is called a bypass trust or a family trust or a residuary trust or an AB trust situation. These are complex formulas that were once used and are still used. So my point is that if a marital trust is established, so let's talk about our third example here, outright to Janet, or a formula clause, or an outright distribution to a marital trust. So let's say Jack had said, I want to use a marital trust because I want to give Janet asset protection, and I also want to make sure that assets flow down to my children, that Janet can't remarry and give these assets to a new spouse. He might have used a straight marital trust of some kind. So when I go back now to the process, we see that the Q-tip election to establish the marital trust is due within 15 months on the Form 706. The portability election is due in 24 months, which is very generous on the part of the federal government. But in all practical terms, these elections would be made probably within 9 months at the time of the initial due date of the Form 706 in many cases. Because this is a probate estate, we see that the first account is due within 9 months in Maryland. The second accounts are due in 6 months increments after that. And what are we very much concerned about if we are representing a fiduciary, or if you are a fiduciary and you are acting on your own? We want a release of liability. The person who posed the question a few minutes ago asked about trustee insurance or fiduciary insurance. Well, this is one form of that. So we want to make sure that if the beneficiary will sign a release of liability or a consent and release and waiver of liability, that's what we want. We want to protect you as the fiduciary. Now, in a probate estate, the court is going to put its final seal of approval on the final account if there are no objections. So that is a protection for you as well. Retirement plan accounts, remember that if you're the personal representative of a probate estate, there is a timeline for claiming these retirement plans. And basically that timeline starts in September and then October, and then all IRAs have to be separated if there's more than one beneficiary into separate IRAs by December 31st of the year following death. So there's usually plenty of time for you, the fiduciary, to make sure that the beneficiaries are claiming their IRAs starting in the timeline when beneficiary designations are permanent as of September 1st, September of the year following the date of death, and then plan documents or excuse me, the plan documents and the trust documents have to be given to the custodian by October, and then by the end of the year, the IRAs have to be separated out into separate IRAs if there's more than one beneficiary. The Secure Act. The Secure Act is just something you need to be cognizant of if you are dealing with a situation where there are people who are exempt from the Secure Act. And let's talk about a handful of exemptions: spouses, people with special needs, people with chronic illnesses, children who are under the age of 18. These are the types of people. Oh, and one more category, which is siblings who are not more than 10 years younger than the decedent. These people are exempt from the Secure Act. It's just something for you to be aware of, generally speaking. Now, when the probate estate is in process, the accountant or whoever's handling the taxes for the estate will choose a fiscal year, and there'll be a fiduciary income tax return. And we know that income tax returns for the estate and trust is 1041, not 1040, and Maryland Form 504. And of course, we have the decedent's final income tax returns. And in some cases, we want a closing letter, either from the state of Maryland or we want a closing letter from the federal government if it has to do with estate taxes and Form 706. Jeff, I'm going to stop for just a second and see if there are any questions at this point.
Thanks, Steve. Right now, no other questions.
All right, very good. And I'm just going to keep on now. We're going to move on to non-probate. So we just talked about an overall overview of a very simple estate process. And now this is the non-probate estate. This is where we probably have a revocable living trust. And why do people implement revocable trusts? Well, many reasons, but usually, and this is the legitimate reason, they should be implementing them to avoid probate. So this example, we're going to assume that everything was in the revocable trust, that non-retirement assets like brokerage accounts, savings accounts, money markets, CDs, real estate, all of these things are in the trust, and that retirement plan assets and annuities generally and life insurance were not in the trust. Now here you're going to see many of the same steps. After the person's death, we want to get date of death values. Now you'll notice here that beneficiaries do get notice. One of the things we didn't really emphasize in the probate process is that beneficiaries get notice. And this is the notice that you see in the newspaper or of the online newspaper these days. Beneficiaries are entitled to notice in probate estates automatically. The interested persons, the people who are in the will, and the people who would have inherited if there was no will. So it's a kind of a brain twister, but those are the people who are entitled to notice. But notice here in the non-probate administration, we have beneficiaries of, let's say, a revocable trust or of an irrevocable trust. And these people, certain of them are called qualified beneficiaries, and they are entitled to notice by law. And so if you're a fiduciary, you must comply by giving them notice. And the question here is, will you give notice to creditors? Well, you do not have to in a revocable trust, but since 2014 in Maryland, the Maryland Trust Act authorized that creditors can make claims against a revocable trust. Now, I have never seen that actually happen, although I'm sure it has happened. But if I were advising a fiduciary, I would say always give notice to creditors. The law gives us a sample or an example of how we can do this and place a notice in the newspaper. I would always do this as a conservative measure. So first of all, qualified beneficiaries are entitled to notice. They are entitled to information. Whether we like it or not, whether we think it's a good idea or not, basically in Maryland, a beneficiary is entitled to all information. In some cases, that's challenging, but that is the way it is, and probably overall for the best. But you'll notice here that there are some very similar things. The alternate valuation date, the spousal election. Now, this slide really should be updated that as of October, we do have, so please correct this on your sheet, we do have the new elective share law. We do have now what is called the augmented estate. And most of the time, this is strictly for the protection of surviving spouses. We talked about this in probate, but it also applies here in revocable trusts. It also, in this example. So it has ramifications for elder law and asset protection for Medicaid purposes. So you as a fiduciary, if there's any kind of long-term care situation and someone has died and left a surviving spouse that has disabilities, you're going to want to be educated about the augmented estate or the elective share. The Q-tip election and the portability election, those things do not change from the probate administration to now the non-probate administration. Disclaimers, same exact thing. The estate tax returns, the retirement plan accounts that have to be claimed, the issues with the Secure Act are the same. The release waiver and refunding agreement, this is something that all trustees should be aware of and should not distribute assets until this is signed by beneficiaries. Why is that? Well, you want to protect yourself and you don't want to, and I'm not trying to be funny or facetious, you don't want to give a disgruntled person money that they can turn around and sue you and cause you all kinds of issues. So you as a trustee want to do your duty, do your job in a very high level, but do not, generally speaking, distribute money to someone who has not signed off and released you from liability after you've done a great job. And the 1041s and other fiscal year and other year estate tax returns, income tax returns, these are all the same. So what I'm hoping to illustrate here by these slides is I'm hoping to illustrate that the concept of administration is the same, whether we have a probate estate or a non-probate estate. What is the difference? The non-probate estate is private. The non-probate estate is privately administered, and it does not have the oversight of the orphans court or the register of wills. Now, with that said, if this is a revocable trust, the circuit court has jurisdiction over the revocable trust. So it's not as if there's no oversight, but it's just that we are dealing with a private administration, generally speaking, versus a public administration. Now, costs are different. Their costs, generally speaking, are going to be higher in the probate estate versus the trust administration, but that could be a myth as well, depending on the situation at death. So generally speaking, revocable trusts are designed to be easier to administer. And what do we want to do if we're still alive and we can avoid problems associated with chaos? We can plan, and we can plan properly and thoroughly, and then we can update over time. And when we update over time and we maintain our plans, now we have a non-probate estate that's going to pass as easily as possible and as cost-effective as possible to our beneficiaries. Now, what are the practical steps that we need to take after a death occurs? So we talked about this a little bit, about being sensitive, being cognizant, being organized, and having resources. So we want to meet with a surviving spouse, or if you as a fiduciary either are the surviving spouse or you're tasked to deal with a survivor or family members, we probably want to get the ball rolling within 30 days, but it doesn't have to be the day after death. I have seen people struggle and labor and just be in terrible pain emotionally and try to force the process forward before they really need to. So sometimes it's necessary, sometimes most of the time it isn't. So I would say be sensitive, take your time getting started within a reasonable period of time. Coordinate with other advisors to provide support. I have found, and many of you may know this or be experiencing this right now, that the survivor is basically adrift. This person whether it's a marriage or a partnership relationship or just surviving children or other relatives. This person is adrift in grief and they really need guidance. Help them to understand the checklists and the critical dates and that everything is organized for their own mental well-being and so forth. Have an inclusive process. Now, there is not always the luxury of having an inclusive process, meaning certain beneficiaries in a probate estate, for example, are entitled to information of a certain kind, but not necessarily all information. And if we are dealing with a probate estate, maybe the personal representative is not going to disclose everything to all beneficiaries, even though they are entitled to certain filings and they're entitled to the final accounting and certain notices. We want to just have a generally inclusive process, because sometimes dealing with difficult beneficiaries is a good idea rather than being non-inclusive. So in other words, we want to use common sense about trying to keep down tension in an estate. We want to exercise due diligence about giving resources to a surviving spouse, a surviving partner, a surviving family member. We want to encourage, again, that everything be methodical and not hurried. And the surviving spouse, many times, or surviving partner, feels like they must engage in the process of estate planning immediately for themselves. This is something that repeats itself over and over, and we want to make sure that that painful process is not too soon, or that it's as painless as possible when this person wants to step forward after the death of a loved one. We want to be organized. As I said, I know I'm being redundant. We want to use either traditional document storage or non-traditional. Traditional document storage would be paper, records, statements, policies. We all know what it's like to have a huge organization box. That would be wonderful. And hopefully the deceased person has left those kinds of things in order. Or in today's world, a digital archive subject to the security things that we all have to be cognizant of today. So organization is the key. Now, what are some of the potentially problematic tax and legal issues we should be aware of? Whether you are an advisor, a fiduciary, a member of the general public, someone who's dealing with the potential loss of a parent, we want to review all assets prior to death. And I'm just going to take a second to check our time. Jeff, it looks like we have maybe another 15 minutes or so before we've gone an hour and a half. So I'll try to be cognizant of that. So organization, maintenance and updating, planning, all of those things make your life as a fiduciary much easier. So we want to review the titling of assets prior to death. If someone is incapacitated, what would you do typically if you were a power of attorney under a broad power of attorney, or a trustee that is acting as a successor trustee when someone is incapacitated? We want to check the titling of all assets. We want to collaborate. We want to kind of get our minds around how assets are going to flow. A lot of these things are common sense, but if we can do that well in advance of an illness, that's going to make your life a lot easier. We want to value all assets after death. So probably one of the most important things to walk away from this presentation with is to know that valuation of assets as of the date of death is your primary responsibility. And we see cases where the fiduciary does not get the date of death assets for months. And this can slow down the administration. It can cause all kinds of problems with the filing of the estate tax return or the election of portability, or it can cause disgruntlement with beneficiaries. And remember, we want to protect you. You want to protect yourself as a fiduciary because you want to carry out all your duties without anyone being able to say that you did not do what you were charged with doing and avoid all of these problems. But valuation of all assets on the date of death and marshaling all the assets, knowing what those assets are and really going after it aggressively, that's going to pay off for you in the long run. caution in retitling accounts and acceptance of life insurance proceeds after death. Now, this is not so much a big issue right now because we have 23 million of exemption federal level, $10 million of exemption for state-to-state tax purposes, and we don't have those extremely low exemption amounts that we used to have. But we may have a problem here coming up with lowering of exemptions. So when someone passes away, if there's a surviving spouse, remember in my example with Janet, Janet had received all those assets from her husband, Jack, and he left all those assets outright to her. And the question was she going to disclaim any of those assets? Well, she doesn't need to right now because of the huge exemption amounts and because their estate was under $23 million. But here in my example, what if we had a very low exemption amount of 1 million or 3 million? Now we might be much more concerned about this issue, and some spouses will accept large amounts of life insurance right after someone passes, and they accept it, they deposit it, they go ahead and spend some of it. And what should we have evaluated? We should have evaluated whether or not any of those assets needed to be disclaimed. So this is something that may be more of a big issue coming up in the future. Inheritance tax. Inheritance tax has to be paid where it is owed. So you as a fiduciary have a responsibility to collect inheritance tax, to let the Register of Wills know, that someone is subject to inheritance tax, and to be cognizant of the fact that inheritance tax is owed if it is owed. So here's a couple of examples. Many times what happens is at the end of the administration, we let the Register of Wills know that we've calculated the amount that's going to be distributed and we're going to pay the inheritance tax. Now remember, in a probate estate, the Register of Wills has already gotten an idea of the amount of inheritance tax that's going to be owed because of the information report that you filled out. You said, yes, there is a niece and she's going to receive assets that are subject to the inheritance tax. So that inheritance tax is paid at the time of distribution. If it's a revocable trust, it's the same thing, except in a revocable trust, we're going to let the Register of Wills know that there is inheritance tax due because there is a form called the application to fix inheritance tax, on on non-probate assets. So application to fix inheritance tax on non-probate assets. This notifies the Register of Wills that in a revocable trust, which is not going through probate, that there is inheritance tax due, and it will be paid at the time of distribution usually. There's one exception, and this is another little nuance that you need to know about, and that is, what if there are retirement plan assets that are paid out? Remember that those beneficiaries are on a timeline and they claim their IRA assets, and that person is a niece or nephew, or it's a friend who is subject to inheritance tax. So now you as a fiduciary need to be aware that you are responsible for paying that inheritance tax, especially if the will says that inheritance tax is not to be apportioned. So in other words, the estate is paying the inheritance tax, or the trust is paying the inheritance tax. And you need to be aware that if that beneficiary received, let's say, a $500,000 IRA, there is $50,000, let's say, of inheritance tax due, and that is due then. It is due now. It is not due at the end of the administration. So inheritance tax can be something that catches up with us as fiduciaries, and we have to stay on top of it. The portability election, as I mentioned, is made in 24 months. The IRS is very lenient on this now, very generous. The rules have been ironed out for the last 7 or 8 years. So not much to worry about here, but we do not want to miss out on the portability election. And there are various aspects of portability that we won't get into right now, but hopefully, regardless of the political winds, hopefully portability will not be going away. The Q-tip election, as I mentioned, has to be made within 15 months. For a marital trust or other trust type situation, this is important. And there is something called a reverse Q-tip election. All of these things are things you should be cognizant of, which is why when you are administering an estate, you want to have usually a collaborative team. You want to have your CPA on your side. You want to have your attorney, your estate planning attorney on your side throughout this process. Failure to foreclose creditors' claims. What if we had a revocable trust and we did not give notice to creditors? We did not say, you only have 6 months to make a claim against this trust. And what if a creditor came out of the blue? Usually not going to happen. As I've mentioned, I've never seen it happen against a revocable trust situation, but I have seen it happen many times in estates. So we want to foreclose or stop creditor claims by using the notice to creditors if we want to be conservative. Now, as we begin to wrap up, how can financial advisors and CPAs and laymen and trustees and personal representatives best work together? Well, we want complete communication with the entire advisory team. If you're a fiduciary watching this, I'm going to advise you to very quickly form an advisory team if you don't have one already prior to the death occurring. And if you're running this administration, you are the fiduciary, I think you should be aware that your advisory team is got great intentions, but a coordinator, a quarterback should be appointed to kind of quarterback the advisory team. That's my advice. And I think that you would know intuitively who should be the quarterback. And that's something that you should expect and you should discuss with them. And that's my second bullet point here. So I'll skip past that one. And we want to invest significant time, if possible, during the decedent's lifetime to make sure, as I mentioned earlier, that assets are aligned, all beneficiary designations are set in stone. And if someone is incapacitated, we want to expedite things, as we see down here in the next bullet point. We want to use our power as fiduciaries to make sure that there's no cleanup items. Is it possible to fix something while the person is still living? Is there power in the power of attorney or trust that allows you to fix this, even if they can't do it themselves? And to expedite meetings of advisors and so forth to accomplish objectives. We kind of sometimes have to turn up the volume and get it to a next level quickly before someone passes away. And I think one of the things that can guide you the most is to ascertain the decedent's wishes. Most wills, most trusts do not have a memorandum of intent signed by the decedent. They don't have a letter of wishes, which is a very similar document that guides you as a fiduciary, tells you what the intention of the deceased person was or is. And so as a result, you are left to interpret the documents, to go through the administration, to keep both eyes open, try to be as sensitive as possible, try to be as technical as possible, try to be as responsible as possible, all on your own without any guidance. So we want to encourage the use of these memorandums. We want to encourage even recordings. There are pros and cons to give you direction. And so this is a highest and best thing that can happen before a time of crisis. We want to encourage people to use advanced organizational tools. This is easier said than done, but it can be accomplished with a systematic way of updating and organizing during lifetime. We want to educate family members. How can you, if you're a family member, how can you know what to do if you've never been educated on these matters and now you find yourself at a time of crisis? Systematic method of reporting to all advisors. We talked about that. Find out who's the quarterback, disseminate information quickly, work with those advisors during the person's life to be organized and to coordinate that organization effort. Again, these things somehow fall by the wayside, and the highest and best approach is to actually spend time doing that. It saves so much problem later. And instill in the confidence of the client that the advisory team is working in one accord. These could be the smartest people in the world, but if they're not working together, there will be problems and there will be inefficiencies. So with that said, that is a very broad 1.5-hour overview, I think, Jeff, of the estate administration process, the trust administration process. I tried to give fair time to the mechanics, but also some substantial time to the examples. We didn't cover every single aspect of those examples, but I hope that you can intuit from those that you could study those examples. And if you have questions, I hope you will email me, give me your questions, give me your concerns, ask for resources if you need resources, because that's what we want to be. Now, along the lines, as I was mentioning earlier in the presentation, that our reputation is to educate and to educate families and to be leading edge, but our reputation is also to give you a path forward. So along the lines of what I just said, remember that you can email me on this slide, steve@elvilleassociates.com. My executive assistant, and we've been working together for many, many years, Mary Gay Kramer. Her email is mary@elvilleassociates.com, mary@elvilleassociates.com. Jeff is here to answer questions and also provide information at jeff@elvilleassociates.com. Or you can call us at 443-393-7696, and you can set an appointment. Now, what we do here is we consult with you, we look at the facts and circumstances of your situation, and we advise. If you're concerned about someone who is near death or is not well, we can look at the existing estate plan, we can advise about how to get things organized and whether there are options prior to the passing of the person. But we want to be here as a resource. If you need a financial advisor referral, if you need a CPA referral, we want to provide those resources about colleagues and resources that we have. So with that said, Jeff, I'm going to open it up to you as I sign off in a few minutes to see if there's any further questions.
Well, very good, Steve. Thank you very much. And a job well done for a very comprehensive presentation, a lot of information in there, and a virtual hand to you. So thank you very much. We do have a few questions here as we wrap up. So I'll go ahead and pose those to you right now. First question is, what is the trust tax rate and how was that determined? Importantly, what if the decedent's federal and state taxes were always significantly lower?
Great question. So the trust tax rate, the highest one right now is 37%. Now, we don't know what that will be in the future, but right now, based on the 2017 Tax Act, the trust tax rates are graduated up to 37%. And what most people are shocked by is to find out that if a trust has income and that income is not distributed out to the beneficiary of that trust, then it's going to be subject to the trust taxation at the highest possible rates, assuming that the income was over $12,800. So at a very low threshold, it gets up to 37% quite quickly. Jeff, I didn't understand the last part of that question. If you could ask that again.
Oh, sure. Okay. Let me jump back to it. Importantly, what if the decedent's federal and state taxes were always significantly lower?
Okay, so I'm going to assume by that question two things. One, during the person's lifetime, if they had low income tax rates personally, and if they enjoyed being the beneficiary of a trust during their lifetime, then if the trust were to distribute out the income from the trust to the person on an annual basis or quarterly basis or whatever it may be, then the trust tax rates would not apply because the trust would have distributed out income to that person at their tax rate. Now, at death, that person's low income tax rates during life would not matter, and we would still be dealing with filing the 1041, which is the trust income tax return, and the trust tax rates would still govern, regardless of what that person's income was during lifetime, except for things like savings bonds and so forth that could be included, savings bond income could be included on the decedent's final tax return. Thank you for that question.
Okay, thank you. Last one it looks like right now. The question is, what is the difference between appointing a coordinator and delegating the responsibilities of the fiduciary, which is not allowed?
That's a great question. So where I'm going with this appointment of a coordinator, it's an unofficial thing. So this is not anything that is a official role. I'm just trying to say that when we are involved or you are involved in an administration process, there are various players. And if those players are not, if they're not in sync, then there can be problems. There can be the CPAs waiting for information, or the attorneys are working with the financial advisors and are not talking to the CPAs, and just various types of people involved, and keeping everyone coordinated, and sometimes designating someone who's going to be in charge of all that at the outset, especially if you're the fiduciary but you have hired a support team to help you, then you should expect that that team is going to coordinate well. And that's my advice there. With regard to duties, I'm going to try to extrapolate what you may mean by that. Yes, there are very much limitations on what can be delegated to someone else to handle, but what your attorneys or support team should be doing, or advisory team should be doing, is trying to do everything they can for you to support you in those things that you must do yourself, generally speaking. Let's say you are the personal representative. Then obviously you have to go to the real estate after someone's death. You have to clean out the house or hire someone to do that. And your attorneys could do that, but most of the time are not going to do it actually themselves. So they can be part of the process. They can create all the filings for you, do all the accountings for you. They can make resources available to you. But if you are the fiduciary, many things you must do yourself, except for those things that you could be assisted with, but you cannot delegate many of those duties. So I just hope by making the point that by having an advisory team to support you as a fiduciary, you are protecting yourself, but that advisory team should be coordinated by someone who is kind of the person who is the point person, if that's possible. Any more questions, Jeff?
No, one question that I can discuss here. Steve referred to checklists, everyone getting a copy of those. I did email those checklists out at about 10:40, so those should be in your inbox if you have not checked your inbox since the beginning of the presentation. So if you didn't get those for some reason, let me know and I'll be happy to resend those to you. So thank you for that question. So again, thank you, Steve. We appreciate your time and expertise today. Thank you to you, the attendees. Without you being here, we wouldn't have a presentation, and thank you for your questions. Again, Steve is here to be a resource for you. You have his email. Mary, his legal administrator and executive assistant, a great resource as well. I'm always here, jeff@elvilleassociates.com. We are all available to be resources and help set times to meet with Steve. And I'll stay on the line here for a few minutes afterwards if you wanted to chat about anything as well. Last thing I'll say, a couple of good presentations coming up. They're new to our workshop series. October 13th, which form of business entity is best for you? That's with Chuck Bork, who is of special counsel to Elville & Associates. He's a great business law and tax attorney. We're very privileged to be working with. Also, our quarterly trustee selection workshop, how to choose the right one for you. And a new presentation on October 27th, VA aid and attendance, a tax-free pension for those that qualify. So without any other questions, which I will just double check one last time.
And Jeff, I just had a quick question. Will you be sending out a survey or anything?
Yes, the survey again will be sent out immediately afterwards. So we, as always, appreciate your comments on that. It is also another good time to request a time to meet with Steve, offer your feedback on our presentation today. You can also suggest anything you'd like to see different on our webinars, or suggest new topics, which we really appreciate feedback about that, that we can look towards for the future. So yeah, you'll be getting that just as soon as we close out this webinar here in just a couple minutes. So,
and I'd just like to say thank you to everybody, and I wish you a happy and a beautiful weekend ahead. So thank you for spending part of your morning with us. And Jeff, I'll turn it back to you to wrap up.
Enjoy the abundant sunshine this weekend. So thank you, everyone. Have a great day. And I will stay on just for a couple minutes if anybody has any questions or comments they want to share with me.